Hi again. So now we are continuing with exclusion or exemption clause. There is a clause that is considered to be a term in the contract. Why is this so important? Because it is going to exclude one party from a particular liability. So basically, this term or this clause is used to increase the liability on one party and decrease the liability from the other party. So the benefit of exemption clause is that it saves litigation cost in case of dispute. Litigation cost is that when you have to define the liabilities, or you come together and you discuss that okay, now this dispute has arisen, what remedies are going to be. So in exemption clause the liabilities are already decided, which is why it saves the cost in the future. However, the major disadvantage of exemption clause is that liabilities are allocated unfairly because one party gets more liability, the other party's liabilities are lessened. Controls over exemption clause. So in order to restrict use of employment clause, two types of controls are applied. One is common law control. Common law control has imposed further two controls over exemption clause. One is incorporation control and the second one is interpretation control. Incorporation control, in this the exemption clause must be mentioned in such a way that the other party gets the notice of it, that the other party, once let's say the exemption clause has been entered into the contract, then the other party needs to be sent a notice that okay, we have included this clause into the contract. Now, example methods of incorporating an exemption clause include giving written notice to them or making them sign the agreement. So definitely they're going to read it and then they're going to sign the agreement. Contractual document if it is a ticket, and by past practice, through whatever your past practice has been with the other party, through that way you're going to incorporate an exemption clause. Now if a clause is very unusual, then it must be incorporated in an unusual manner as well, which means that it needs to be given extra importance. It needs to be highlighted specially so that the other party puts a lot of attention to it. Now, for exclusion of liability in case of deliberate act, court of law regards this law as an unusual clause and it requires incorporation in an unusual manner. That is just an explanation to the incorporation control. Interpretation control, in this they are going to use two rules, contra profantem rule and main purpose rule. Contra profantem rule says that as per this rule, court of law follows strict approach, and if an exemption clause is found to be vague, then the court of law is going to interpret it against the party. Against what party? Against the party who incorporated this law. So definitely the party who has included this exemption clause into the contract, they would want to increase the liability of the other party and decrease their liability, which is why they're probably doing it, right? So going against them means that you're actually treating this exemption clause as void, so that whatever their main purpose was, now that main purpose has been considered to be vague and this main purpose cannot be fulfilled. Liabilities for deliberate acts and negligence must be excluded specifically, otherwise that clause will be void. So make sure that you also include liabilities if somebody acts deliberately on that in adverse effect of that clause, and just in case if somebody by mistake or they did not exactly know a lot about the clause and they just acted upon it, then in that case what is the liability for them? That should also be mentioned. Main purpose rule, So as per this rule, an exemption clause that affects the main objective of the contract will not be enforceable. As long as that exemption clause is increasing the liability of one party and decreasing the liability of the other party, but keeping in line with the purpose of the contract, that is fine. But if it is not keeping in line with the purpose of the contract, then it is not enforceable. Statutory control. According to common law controls, an exemption clause is valid if it is validly incorporated and is clear. So this approach may result in unfair clauses being enforceable. As strong bargaining position may easily bypass these controls. So this often happens when one party is very strong. Let's say if one party has a backing from the government and the other party is just a usual party, then in that situation this can happen. In order to resolve this issue, following two statutes are made: Unfair Contractual Terms Act (UCTA) and Unfair Terms in Consumer Contract Regulation (UTCCR). UCTA, according to this act, all exemption clauses are void if they are not reasonable. If they are reasonable, then that is fine. But how will you know whether they are reasonable or not? So there is a test for reasonableness. So in this case, this act provides special support to consumers, where consumer is defined as one who do not perform business of that commodity and has not purchased that commodity from auction. What do they mean? They mean that this act is going to specially support consumers. For example, the UK consumer law. This UK consumer law, why is it made? In order to protect consumers, right? So who is a consumer? Who is not involved in the business community. He is rather just coming to purchase your product, right? And he is purchasing that product not from auction. He is rather coming to your shop or to your factory or to your warehouse to purchase that product. Such a person is considered to be your consumer. Now UCTA has defined following circumstances. What are the circumstances? Liability for negligence. So as per UCTA, any exemption clause which excludes liability for negligence is void, because you need to mention what is the liability for a person who is being negligent. Liability for non-performance. Again, any such exemption clause which excludes the liability for non-performance will also be considered void. Liability for misrepresentation. Any exemption clause which is not going to include the liability for misrepresentation is also considered to be void. Exclusion of liability in guarantee. Any exemption clause which excludes statutory rights for anybody is void. If you're giving up on the statutory rights, or if you're not paying attention to the statutory rights of, let's say, employees or of any other party who is in contract with you, then in that case that is also considered to be void. Limitation of liability and guarantee. In this situation, any exemption clause which is going to limit the liability in guarantee is going to be considered as void unless it is reasonable. So if you have a good reasoning for it, then that is fine. Otherwise, if you are limiting the liability in guarantee, then that exemption clause is considered to be void. Now, what do we mean by limiting liability in guarantee? If you remember, we have studied that there were different kinds of companies there's one that has limited liability, then there's one that is limited in liability by guarantee. Guarantee means that one party has to give a guarantee that okay, if I do not perform, then take this away. For example, when you go to take a bank loan, you have to give bank a guarantee that you are going to pay back, and if you don't pay back, they are going to take some of your belongings away. For example, if you go for a car loan and if you're not able to pay back, they're going to take the car away. Similarly, if you have bought a house and you're not able to pay back, then they're going to take your house away. Okay, so this is limited liability and guarantee. Now, test of reasonableness. So while determining whether an exemption clause is reasonable or not, there's a reasonableness test that UCTA has mentioned. If exemption clause is introduced by a party in stronger bargaining position, then it is going to be treated as void. Sometimes this happens that one party is very strong, the other party is not strong, so the other party, the one that is less stronger, usually agrees under pressure to all other clauses. If any inducement or benefit is given against an exemption clause, then that clause may be treated as valid. So if you are giving the other party any benefit whilst you are mentioning an exemption clause, then that is considered to be valid. There is no problem in it. Third thing, if both parties are aware of exemption clause, then it may be treated as valid. Any exemption clause which becomes applicable due to act of victim may be treated as valid, and any exemption clause which relates to special order goods may be treated as valid. Now, unfair terms in consumer contract regulations, UTCCR. This act deals with unfair terms in consumer contract, where consumer is defined as the person who is not performing business of that commodity, rather he is just coming and buying that product, and that too not from an auction. Unfair term is defined as any term which is not clearly mentioned. Let's say you have used a lot of jargons and the other party is not expected to understand, or you have not used a language that they understand, then in such a situation, such clauses are considered to be vague or void. End of contract. So the contract may be due to following reasons, that are performance. You require performance from the other party, which is why you're doing the contract, or you are doing the contract maybe due to frustration, that okay, the previous contract was not fulfilled by the other party, so let's do this new contract and let's give them a chance to keep up with their promise. Loss of capacity of one party, that is cancellation of legal license. So therefore you have to, let's say if you were producing something previously and you had the license for it, but now your license has been cancelled because you probably got into wrongful trading, so you're going to go to the other business and you're going to do contract with them that okay, I am placing this much orders with you, I want this product to be made. So why is the first party doing this contract? Because they have lost their capacity to do the work themselves. Then mutual understanding, and third is breach of contract. So breach of contract occurs that if any clause of contract is not being treated as it should be treated, then it is considered to be a breach of contract, and the injured party, the one who is being affected, can file a case or can sue the other party within a reasonable time period. However, if the injured party does not want to sue or does not want to do a case, rather they want to continue the contract without any claim, they can do that as well. However, if a condition, not the warranty, if the condition, which means the term of the contract, is breached, then it is considered to end. Anticipatory breach of contract. is going to occur when a clause in the contract is breached, and this breach of contract has been done on performance day, when the person had to perform. Let's say I had to deliver you goods today, but I did not end up delivering it today. Rather, I told you that I need 10 more days. So any breach that I have done before the performance day or date is not going to be considered valid in this case. Rather, the breach of contract that I am doing today is going to be considered as anticipatory breach of contract. So the anticipatory breach is let's say if it is accepted, then the contract will end immediately, and if it is rejected, then the contract will continue as normal. Rather, you would give me 10 more days to fulfill my promise. So anticipatory breach plus acceptance is equals to breach of contract. Now remedies for breach of contract. So in case of breach of contract, damages are rewarded, that is monetary compensation, quantum merit. This is again a common law remedy, and it is considered to be a monetary compensation. Then we have specific performance. This is again a non-monetary compensation. We have already discussed all of this. Injunction, non-monetary compensation, recession, non-monetary compensation. So damages you already know. Let's revise the specific performance, the quantum merit, injunction, and recession. So in case of specific performance, you are required to actually perform that promise, fulfill that promise that you did before, and act in a particular manner as you had already promised. Quantum merit is that you have to offer services, because let's say the second party, let's say you have paid me for the services, right? You've paid me to teach you. So either I'm going to act on it, I'm going to provide you the lectures, that is specific performance, or I have to pay you back the money, that is quantum merit. Then we have injunction. So injunction, you know that the other person is told to be vigilant and not to do that activity again. Let's say if somebody has disposed of garbage in the river, and the court has called them for a hearing, and now after the hearing, the result was that the court gave them another chance, and the court has told them that don't do this again, otherwise we are going to cancel out on your license. So if the person is asked not to perform something, that is injunction. Now in case of rescission, there is not recession, this is actually RESCISSION, rescission. So in that case, the other party gets the right to end the contract. Damages you already know are monetary compensation that you pay. Kind of damages, general damages are going to allow you to pay a compensation for the direct loss that has occurred to the second party. So in this case, generally damages are to be paid. Special damages, in that case, it is a remedy for indirect loss. Let's say you did not intend to hurt somebody, but because of your decision you ended up hurting somebody. For example, you dumped waste into the river. Now your intention might not be to, infect people. You probably didn't even know that people were drinking water from the river. But after 2 to 3 months, somebody came to you and they told you that, okay, in the nearby village somebody has passed away because of you dumping waste into the river, because people used to drink water from there. So in this case you have to pay special damages. Remoteness of damages. Special damages can only be awarded if they are in reasonable contemplation of parties. Otherwise they are not enforceable. So what is reasonable contemplation? If it is a normal scenario. If it is not a normal scenario, then you need to specifically be given a notice. Measures damages, expectation interest. As per this approach, parties are awarded what they expect from the contract. So if actual results are less than expected, then remedy is awarded to compensate for the deficit or compensate for the decrease in your reward. If actual results are greater, then no remedy is going to be rewarded. Now, if the objective of contract is achieved but expectation of parties is still not satisfied, then the court may consider cost-benefit analysis. If the objective of contract is not achieved, then cost-benefit analysis is not going to be ordered. Rather than that, the party has to give them the remedy. Reliance interest. In this case, court of law is going to award remedy that is going to be equal to the amount of expenses that are incurred in case of the reliance of contract. Let's say if the injured party has been put into such a position where they are being affected actually, then in that case you need to pay for all the expenses. Let's say the injured party does not have enough amount to do the case, but they have taken loans from somebody in order to bring you to the court so that they can get the remedies from you. So in that situation you have to pay the remedy equivalent to the amount of the whole case that they are doing against you. Mitigation of loss. As per this rule, it is the duty of victim to reduce his loss as much as he can. But if the victim has failed to reduce his loss, then no remedy will be awarded. What do we mean by that? Often this happens that employees are told by the employers that make sure you take certain precautions when you do the job, but the employee has not taken any precautions, and rather than taking precautions, he just started his work generally in normal clothing, without any safeguard equipment and all, and he ended up getting hurt. So in that case, he was the one who did not mitigate the loss. So the employer is not going to pay him any remedy, and he cannot even demand any remedy from the employer in that case, because the employer had already told him that you must take precautions. Nominal damages. These are damages that are awarded in case of breach of contract, not because the victim has suffered any loss, but because it is the remedy for breach of rights. So these are of comparatively smaller amounts. Liquidated damages and penalty clause. Generally, remedy is mentioned after the breach of contract. It is computed after the breach of contract because remedy is a compensation for the loss. So definitely, if it's a greater breach of contract, then more remedies will be paid. If the breach of contract is a very smaller one, then lesser remedies are going to be paid. So in some cases, remedies are predefined in contract. So you list down all the possibilities of breach of contract in the contract only, and you mention all the remedies for each of the kinds of breach of contract in that as well. But if the amount payable to victim is more than the loss, then it will be treated as a penalty. If the predefined remedy in contract is a genuine pre-estimate of loss, then the clause has following characteristics. Then in that case it is considered to be a liquidated damage. So as per the contract, if you've already discussed on a remedy and if you've already written down the remedies, by estimating the loss before it actually happened, then this will be considered as liquidated damages. So first thing, claused amount must not be greater than contract price. Second thing, claused amount must not determine a single remedy for all kinds of losses. If liquidated damages are considered to be genuine, only then they will be enforceable. Otherwise, the actual amount of loss will be considered and you will be paying remedies as per that thing. Specific performance, we've already discussed. In that case, you can't pay monetary rewards. Rather, the other party who's actually done the breach of contract needs to perform properly now. Injunction is the enforcement of negative clause, where this negative clause is going to restrict the person from doing a certain act. So I gave you that example that if you have dumped waste into the river and you've been caught by the court, you've been called for the hearing. Now the court is going to mention it to you that don't do this activity, otherwise you're going to cancel out on your license. Right now you just have to pay, let's say, a monetary damage, but if you do it again, we are going to cancel out on your license. Quantum merit is about the rights of a particular person. So in case of breach of contract, a person will be paid for the work he has already completed. Rescission. In this case, parties end their contract with mutual consent. That is, no one is considered to be an injured party. But this needs to be made sure that when you are ending the contract, the third party should not be affected by it.